Hello. The idea that it's better to ask a lawyer or another specialist, depending on the context, in advance, beforehand, so before something has happened already, this idea is quite common, and I believe, like intellectually, honestly, everybody is aware of that and probably mostly agree. But unfortunately, when it comes to legal issues, particularly when it comes to significantly expensive legal issues like real estate transactions. Not everyone, to say the least, is ready and prepared and even think of asking a lawyer and a notary before. So let's talk a little bit of the questions that might have been asked beforehand, in advance, to save significant money later. It's like really, literally $100 before, hundreds dollars before, and several, maybe 100,000 after. So this is the difference. Um, so here it is. Often, especially those who buy property in Quebec for the first time and being originally not from Quebec, so those people have some assumptions from their own provinces or like other jurisdictions, how it should work. And this notion of promise to purchase, because of that promise, I think, many see as some preliminary step, like a start of negotiations, like the first step of it, while in fact, this promise to purchase, promesse d'achat form, it's already a binding contract. So once it's signed, all together with the seller's declaration, to which again the seller is liable if later something goes not as is described, as it is described in the seller's declaration, there might be a significant problem after. Therefore, however, your real estate agent is trying to skip that part and to just diminish the significance of that. Whatever a problem with the property that you know of, or at least you suspect that it might be there, and you did not check in the seller's declaration or did not just mention in the seller's declaration, later on, significantly after the purchase, a buyer can come back after you for a significant amount of money. So do not take this promise to purchase and all the attached documents lightly. Of course, in the same promise to purchase, there are usually clauses allowing to get out of this contract, but for very limited and specific reasons. And the simple fact that later on you found a better buyer, or you just changed your mind, or you just didn't like because of some advice that you got later on, because later on you only started to analyze the market. Later on you suspected that your real estate agent didn't tell you everything. Later on you just talked to your family members. Later on you finally met a notary or a lawyer. It's too late. So remember that promise to purchase is mostly, in the most of the situations, a legally binding document, meaning that if later you try to change your mind, it's not only that you will have to pay something to real estate agents and maybe some compensation, but you might be even forced to sell by the court order because you already promised to do so. When you're buying some commercial property, you might assume that it will be suitable for whatever you're planning to do in there, but there might be zoning problems, there might be some restrictions, might be some particular municipal regulations, or it might be like agricultural land, for example. Uh, and not only you couldn't do what you planned to do there, hence again Montreal laws, but you also might be in a situation when selling this property uh, is a hard task because of all those limitations. And you might later on try to go against a notary who advised you, if you got that advice, a lawyer, a real estate agent, or inspector, whoever. But if you got all those advices, but if you simply proceeded under an assumption that it all works the way you did it in some other jurisdiction before, it might not work well for you. You might be at a loss. You might be at a considerable loss later on. And as the documentation might be quite clear, it's not unusual when nothing really can be done about that. So this lack of due diligence about asking those questions before will bite you back later, sometimes significantly later. You might not even realize that there is a problem until years later you would start trying to sell the property, and voila, you would find out that you cannot, for the value and for the purpose that you think you'd like to. The title for the property, because like it's a technicality, but in legal reality, it's a significant technicality. You're not buying and selling property itself when it comes to real estate property. You're buying a title to that property, the right for that property, to put it in layman terms, if you wish. And if the right is dismembered, in a sense that, for example, you own, yes, but somebody has a right of use, or just tenants' rights, especially when it comes to residential property. Or there are servitudes. Even in a townhouse or in a condo, there might be some servitudes regarding some pipe going through your property, or some right of passage attached to that property or to your property. Not to mention the usual servitudes for electricity and other municipal things. And there might be a right of view, for example, which you wouldn't even think of, but later on it would appear that, are you an owner of the property? Yes, but what you can do with the property, it's again significantly limited. So the real value of the property might be lower than you think. So again, significant loss if you did not verify that. So particularly in Quebec, when we have like separate profession notaries who can do the historic search for the title, who could verify what was attached, what was not. For example, long ago, there was a one big building, and there was a family that had some grandfather who actually built it all, and then it was split in the family, 1, 2, 3 generations, portion. Then maybe it was converted to a condo at a certain point. Then maybe it was sold, most probably it was sold further in history to some really unrelated people. And then suddenly what was never a problem long ago, like, for example, one general drainage route in the building for everyone, or some pipes just hidden in one particular wall, or some space in the uh, basement that was like allocated through all these years for that because it was always there. But technically, whose problem is it now? On whose property right it encroaches now? That might be a problem. Some small walls, which are just to separate property, might be moved back and forth. And eventually, like roof, sections, attic. Uh, Eventually, one person might think that he or she has all the right to have it there, to use it there in the part of somebody else's property, and that somebody else thinks that, well, at least pay for that or just help to pay for repairs or just create your own and so forth. And the answer, who's right, who's wrong from the legal point of view, will be there in that historic title search. Like, what rights were attached to what title, or were not, or maybe there should be a significantly lengthy and costly litigation simply to clarify those rights. And if you verify all that before buying that property, you might buy it at a lesser price or just even avoid getting yourself into all that mess, especially when it comes to indivision as opposed to condos, which are not uncommon in Quebec. Also, who pays what, but for the purchase price, it's also an important question to ask in advance, like taxes, who pays what, to whom, what kind of money will be stuck in the notary's and trust account until the taxes are paid, who pays for real estate agent and what percentage, what are the notary, and so forth and so forth. All those questions are better to be answered before. If you're buying a condo again, technically it's your responsibility to verify with the syndicate. In other provinces it's called condo corporation as far as I remember, like the ownership agreement, the bylaws, the building regulations, what is the contingency fund, what are the fees, what are the plans to maybe increase those fees. Because, for example, at this point, everything seems okay, but there are already plans in motion with the syndicate to initiate some costly renovations or repairs next summer, for example, and out of a sudden, you might find yourself facing significantly higher costs of owning that property than you were expecting, for example. And again, it will be a significant part, or maybe 100% part, even your responsibility. So that as a diligent buyer, you should have verified that. Of course, your real estate agent technically should have advised you, but not all of them do, honestly. So instead of facing later a litigation against the seller, trying to prove that the seller knew of all those problems in advance, or maybe the seller didn't, against the inspector who should have noticed, against the syndicate, or if you are the seller, just to face all those litigation points with the buyer if you did not inform in advance again, it's better to verify all that information, to ask all those questions, to consult a lawyer, a notary, an accountant, the syndicate, sometimes an inspector, sometimes even like municipal inspector if necessary, so that you would save yourself a lot of time and money avoiding further legal problems. So this is it. We are back to the very idea. If you don't think that you have questions to ask before you are getting into some sort of legal transaction, then that might be the first question. What kind of questions should I ask? And if you think that there are no questions that you should have asked, then you're definitely missing something, and you're definitely heading to some kind of legal problem. Ask questions, ask them before. Thank you and have a nice day.